Hi friends, welcome to this episode of LAWBY Podcast. I am Arun Sugavaneshvar, and today we are going to find out how law protects love. Yes, law protects love, and in fact it is quite serious on this issue. So what do you guys think is common between the movies like Dadak, Khap, Sairat, Pariyerum Perumal? Apart from the fact that these movies received critical acclaim, they also spoke boldly on a very delicate topic that still has many confused. Why should caste have a say in the matters of love? They discuss the inexcusable interference of caste differences on the personal rights of two consenting adults who attain the age of majority. Before going into the law-protecting love segment, let us see why caste has this much power to overpower something as compelling as love. Something that compelled Elvis Presley to sing the famous lines, "Take my hand, take my whole life too, for I can't help falling in love with you." Let's break it down. We know the problem creator. So what is this? The caste system is more of a social setup that helped in allocation of work. Unfortunately, for a thing that has been around for almost 3,000 years, it has not factored in elements of skill transferability, choice-based occupation rights, and it has this rampant ailment called subcaste that creates a little bit of chaos by itself. Bottom line, it is a poor and outdated method to help a human find his or her calling and contribute to societal growth. Now, this seems to be the unnecessary element of social status that came out of this design of caste system that irks the ego of people who were placed in a higher status of respect earlier. To me, it seems that love is the auto solution to the problem of caste, as it effectively promotes intercaste marriages. To better understand this topic, we have segmented this episode into 3 parts. 1. Why should law protect love? 2. How does law protect love? 3. The way forward. Now, why should law protect love? The bitter truth is that people who loved each other from different castes were killed by their own kin, and the killings were titled honor killings. An interesting fact for you. In 2012, the Law Commission of India recommended that separate law be created for the tackling of honor killings. As part of that report, they had drafted the Prohibition of Interference in the Freedom of Matrimonial Alliances Bill, which criminalized even threatening and intimidating couples. The NCRB, the National Crime Records Bureau, started recording honor crimes only from the year 2014. It also so happens that the honor crimes are recorded as kidnapping, murder, and causing bodily injuries under the IPC, as India has no dedicated legislation till date to battle honor-based crimes. Now, this is where things get interesting. We look at the foresight of the drafters of our constitution. It is quite phenomenal to note that the drafters of our constitution understood the deep-rooted division amongst our people and brought into the constitution protective mechanisms. Right to equality under Article 14 clearly enshrines that the state shall not distinguish any of the Indian citizens on the basis of their gender, caste, creed, religion, or even the place of birth. The state further cannot refuse equality before the law and equal defense of law to any person within the territory of India. The right to social equality and equal access to public areas is clearly brought out under Article 15 of the Indian Constitution. Article 16 of the Indian Constitution clearly states that no citizen shall be discriminated on the basis of race, caste, religion, creed, descent, or place of birth in respect of any employment or office under the state, though with certain exceptions. Article 17 abolishes the practice of untouchability in India. It declares it as a crime, and anyone doing so is punishable by law. And Article 21 deals with right to life respectively. In the case of honor killings, these rights are violated. It is the right of a person to choose his or her life partner, and nobody can take away that right. Despite all these constitutional assurances, not a day goes by where the evils of caste plays havoc in our justice system. Probably every citizen of India understands the importance of caste in the electoral process, and every political party weighs the strength of the candidate in the constituency by understanding his or her background to better their odds of success. So it's really interesting that the constitutional drafters created this failsafe without which even law would have been a mute spectator now. So moving on to segment 2. So how does law protect love? We will use the support of case laws where the courts have taken cognizance of such honor crimes and intervened effectively to protect the rights of individuals. The landmark case in this regard was Shakti Vahini vs. Union of India and others. In this case, the petitioner, Shakti Vahini organization, was authorized for doing a research study on honor killings in Haryana and Western Uttar Pradesh by order dated 22/12/2009 passed by the National Commission for Women. It was observed that in Haryana, Uttar Pradesh and Punjab, tendency of honor killings had increased, and it created a fear among youth who intended to get married out of their caste. According to NCRB report, in the year 2014, 2015 and 2016, 288 cases of honor killings were reported. It was contended in the petition that a parallel law enforcement agency and the nomenclature of Kap Panchayats had emerged. These Kap Panchayats resorted to beating of people, shaving of heads, calling for social boycotts, or even killing by a mob. The Supreme Court, in its landmark judgment, held that the Kap Panchayats or any other assembly must refrain from taking law into their own hands. They cannot assume the role or character of a law enforcement agency or any agency of a state. It was further directed that if any Kap Panchayats gathering happened in the knowledge of a police officer or district administration, then one must inform the DSP or Superintendent of Police in that jurisdiction. The Supreme Court mandated the Superintendent of Police and District Magistrate to ensure the safety of couples of intercaste marriages by taking steps including providing safe houses and police protection. With the lack of any specific legislation, the courts are combating the menace of honor crimes, borrowing support from IPC, and it would be high time for the Parliament to legislate on this matter. Another case where the Supreme Court intervened was the Hadia case. This was a case of interreligious marriage. In early 2016, Hadia's father reported her missing and further filed a habeas corpus petition in the Kerala High Court. Hadia had converted to Islam and married Jahan, a Muslim. Hadia, formerly known as Akila Ashokin, her family alleged that she was brainwashed and forced into this marriage. However, Hadia herself refuted such claims and said that she had married of her own volition. In May 2017, Hadia's marriage was annulled by the High Court of Kerala on the grounds that Hadia was allegedly a victim of psychological kidnapping and that marriage was a sham. Jahan appealed against the High Court order and moved to the Supreme Court. In March 2018, the Supreme Court restored Hadia's marriage, declaring that the right to marry a person of one's own choice is part and parcel of Article 21 of the Constitution. The Hindu Marriage Act 1955 has no mention of gotras or castes while deciding the validity of a marriage. Section 29 of the Hindu Marriage Act 1955 states that a marriage solemnized between Hindus before the commencement of this act, which is otherwise valid, shall not be deemed to be invalid or ever to be invalid by reason only of the fact that the parties thereto belong to the same gotra or pravara or belong to different religions, castes or subdivisions of the same caste. In fact, there is no legislation that prohibits the union of two consenting individuals. However, the play of caste still persists and the courts are working round the clock to help victims of honor crimes. Now moving on to the third and final segment, the way forward. Our constitutional mandates are clear. The acts are clear. Intercaste marriages are legally valid and will be protected by law. But what is unclear is how to change the attitude of caste-driven feudal minds. Have you guys heard of Dr. B.R. Ambedkar's scheme for social integration through intercaste marriage? This scheme runs Rs 2.5 lakhs for marriages where one of the spouses belongs to the Dalit community. It is quite heartening to see that the central government promotes SC/ST intercaste marriages through such schemes. Even state governments have their own independent dedicated schemes for intercaste marriage. For example, the government of Himachal Pradesh, to promote intercaste marriages and encourage social integration, provides financial assistance of up to Rs 75,000. State government of Karnataka, through its social welfare department, provides financial assistance of up to Rs 3 lakhs for such intercaste marriages. All these schemes come with certain eligibility criteria, that the marriage should be an intercaste one in nature, the bride and groom must have attained legal age, the application must be done within say 1 year of the marriage, and many state governments are developing their own independent schemes to promote such intercaste marriages. The way forward is quite clear. Intercaste marriages are legally valid. The courts have sanctified the right of a person to choose their partner. The courts have mandated and directed the central government, state government, and police authorities to protect intercaste couples. Finally, it would be best if the great Indian Parliament enacts a special legislation to tackle honor crimes. This brings us to the end of this episode of LAWBY Podcast. Thank you for listening to us. Kindly do subscribe and support. Stay lobbyfied.